All right, so we're here, King Law Podcast, and we're going to talk about DWIs with Bob and Jerry. So, what is a DWI?
So a DWI is a case that you see a lot as a prosecutor, you see a lot as a defense attorney. I've represented a lot of people for driving while intoxicated, and there's a couple different types, so we're going to try to go through what the different types are. Your classic driving while intoxicated case is usually a two-charge case. There's two types of DWIs. DWI stands for driving while intoxicated. A lot of people refer to it as driving under the influence. That's another state. In New York, driving while intoxicated is one of two things. Either the police are alleging that the driver did not have the ability to drive as a reasonable and prudent driver, meaning they didn't have the physical and mental ability to drive as a reasonable and prudent driver, or the other type of driving while intoxicated is all based on a breath test. So driving on a public highway with a blood alcohol content 0.08 or greater.
So just kind of to recap, we call them in our terms, layman terms, you have refusal tests and you have breath tests or sometimes blood tests in some circumstances.
That's right. So usually when an officer makes a decision to arrest, he's basing that on what his observations are and investigation at the car. Then he'll usually he or she will take somebody back to their barracks and try to do this breath test. If they get the breath test, they charge the second type. If they don't get the breath test, then they do the refusal.
What if the refusal, and also, do they always take you back to the barracks, or will they do it there on site?
So there's two different types of breath tests. There's one that's called a preliminary breath test. In the field, everybody calls it PBT. What that is a little roadside breath test that the police can administer, and a lot of times they do, but it's been determined that it's not admissible in court. So a lot of times they'll pull out this little gadget and have someone blow in it, and it does produce a number, and in some cases that number will be in the police's paperwork. Otherwise, a lot of times you'll just see positive or negative, and usually in these cases it'll just say positive, and then they go back and they at the barracks do the formal breath test using their fancier equipment.
So just explain to people the elements of a DWI charge, what the prosecution would have to prove someone guilty of a DWI.
So first they'd have to prove driving, or operation is the more technical word. They would have to prove that this was on a public highway and that there was intoxication. And again, there's two different ways of doing that depending on the charge. There's based on the officer's observation that the person couldn't drive as a reasonable and prudent driver, or the breath test. So it can get pretty confusing because you'll see cases that are they're accusing the person of operating, yet the car's stopped, or that the car's not turned on. Same with public highway. We've seen DWI cases in parking lots, and there's a whole analysis you go through to find out if a parking lot is a public highway or not.
I think it's 4 or more spaces, if I remember.
Right.
What is the difference between a DWAI versus a DWI?
Right. So again, DWI is driving while intoxicated. DWAI is really driving while ability impaired by the consumption of alcohol. So it's driving while ability impaired by alcohol is the lesser of the two. Driving while intoxicated is the more serious. And there's a lot of big differences between them. So one, the big difference is if you're convicted or plead guilty to one of these, the punishments that come along with it. In an intoxicated conviction, there's a 6-month license revocation. For an impaired, there's only a 90-day suspension. A DWI, intoxicated, is a crime. It's a misdemeanor. Driving while ability impaired is a violation level offense. It's not a crime. on a DWI intoxicated, there's a requirement to have a breathalyzer in the car. That has to go in the car for a year. You can make an application after 6 months to have that taken out of the car, and then it's up to the judge. There is not a requirement on an impaired. So there's a big difference in fines and surcharges. It can be about half as expensive on an impaired as compared to an intoxicated, but it really depends on the case. A lot of times it not being a crime is a big motivation, is a big a piece of the outcome that's really important to a lot of the people that we represent.
Yeah, we defend whole cases to try to get a charge of a DWI reduced to a charge of driving while ability impaired. Protect the criminal record, not have to have the breathalyzer test in the machine, saves you a bunch of money, but that criminal record's forever. So the difference between someone being intoxicated, the way I think of it is drunk, or somebody who had a couple beers and impaired to any extent is the law. Something that we can defend on quite a bit. We can negotiate, but we can also try to convince a judge or jury that maybe they weren't really intoxicated, but a very typical defense for us.
And it's kind of interesting. Sometimes it is a negotiation trying to get to an impaired. Potentially you could have a case that goes to trial that is charged as a driving while intoxicated, that you are just trying to win it all, meaning not guilty across the board, or take it to the end. Sometimes the strategy is to go to trial to get the impaired. It all depends on the case.
So what's the difference between a DWI that's a misdemeanor versus a felony?
So almost any time it's somebody's first time being arrested for driving while intoxicated, it's going to be a misdemeanor. There are some exceptions to that. If really there's two. If someone is driving while intoxicated and has a minor in the car, it can, on a first offense, be charged as a felony. And if somebody's license is suspended and they're driving while intoxicated, it can also be charged as a felony on a first attempt. But normally the way that you would see it is if it's someone's first time being charged with driving while intoxicated, it would be a misdemeanor. If they have a prior conviction for driving while intoxicated and they're being charged for another, what would be misdemeanor driving while intoxicated, it'll be charged as a felony most times.
Yeah, so when we're talking about DWI versus DWAI, that's in the New York State Vehicle and Traffic Law. It's a little bit different. So we have 11 DWI, 1192 subdivision 2 is per se DWI, which is over 0.08 blood alcohol content, or 1192 subdivision 3, which is incapable of operating as a reasonable and prudent driver. And then DWAI, what we're talking about, or sometimes we call it an AI, or driving under the influence, is 1192 subdivision 1 of the New York State Vehicle and Traffic Law. So that's where you would find it. That's where you would find the law. Felony DWI most typically is a prior conviction within 10 years. There's some other exceptions to that if you have a suspended license, if you have a kid in the car, but I would say 90% of the time our felony DWIs are prior conviction within 10 years. So.
One thing I think that's really interesting is, even since I've been doing this work, DWI cases have changed quite a bit in the last 5 or 10 years. And I think one of the things that changed that is the introduction of body cam.
What role does body cam play in a DWI defense?
The video is going to either be played in negotiations or it's going to be played at a jury trial. So if the defense is he wasn't falling down drunk, we play the video and say, watch the video. He's not slurring his words. He's doing pretty well on those field sobriety tests. You just watched him stand on one leg in winter. Whatever it is, it's putting yourself at the crime scene as a defense attorney or the prosecutor and saying, let's watch this video and see what actually makes sense here.
Well, there's also like glassy eyes, they check the box and it's like you can see in the video whether that's the case or not. But also it's like, what is glassy eyes? My eyes could be glassy, but I haven't been drinking, so. But it's good material to have.
99% of DWI cases, you're going to see in the paperwork or in the testimony that the smell of alcohol was coming from the operator's breath. He had bloodshot, watery eyes and slurred speech. You usually won't see a case where one or two of those things are listed. It's 99% of the time, all three.
So I'll ask the question, but what are some of the common defenses that we're looking into in a DWI case?
That the prosecutor cannot prove operation. The vehicle is not moving. It's either off or it's parked. We've had cases where our clients were sleeping in the vehicle. They had no intent to drive. The DA's office or the police could not prove that they intended to drive. They were going to drive. The hood of the vehicle wasn't hot, whatever it was. So operation.
I'll jump in there. Stop. We're defending DWIs on the stop of the vehicle. Did the police have a reason to stop the vehicle? And what's the legal standard for stopping a vehicle?
There has to be a traffic violation. So there has to be reasonable cause that there was a traffic violation. So no tail lamp crossing the line. There has to be a reason to stop the car.
They'll try to push public safety. Very limited why you can stop a vehicle if there's not probable cause to stop for a traffic violation or a crime being committed. And then we defend a lot on probable cause to arrest being standardized field sobriety tests. So just talk a little bit about what role standardized field sobriety tests play in a DWI case.
So the standard field sobriety tests are really big, mainly towards that DWI that is not breath test oriented. So there's the two charges. One is driving on a public highway 0.08 or higher. The field sobriety test will come into that charge, but specifically, could the driver operate as a reasonable and prudent driver? They're going to try to compare the field sobriety tests to driving, that it's multitasking, that it's physical, that you have to follow directions and you have to be physically and mentally sharp. So there's three main tests that they do. The first one is horizontal gaze nystagmus. It's an eye test. The officer puts a stimulus in front of the driver's eyes and has him or her follow the stimulus in a couple different ways. So what they're basically looking for is they want to see if your eyes shake in their corners or vertically. So they're moving a stimulus and then watching your eyes. And if your eyes are jerky, they're saying that there's nystagmus and it's a clue to intoxication. The next test that they usually do is called the walk and turn test. This is a really tough test, actually. They give you a ton of directions. They have you stand with one foot in front of the other. They give you instructions to take 9 steps down, 9 steps back. They give you a little specific instruction about how to turn and a 2-second demonstration and ask someone to do this test. So there's about 30 or 40 opportunities to make a mistake in this test, and they count it as a fail if someone has 3 mistakes. That's not touching their heel to their toe. That's turning the wrong way, starting too soon, going offline, using their arms, all these different types of things. So it's that, and then there's the one-legged stand where they're asking you to put 1 foot 6 inches off the ground. Don't use your arm for balance. If you put your foot down, bring it right back up and count out loud. They're looking for 2 errors in that test. So they do these 3 tests, and then they do a little score sheet where they keep track of how somebody did, and then they're going to try to prove that they were intoxicated based on how they performed on these tests.